Thousands of consumers and workers each year are injured and contract disease as the result of exposure to hazardous chemicals and toxic materials. The injury may take the form of a burn or may take the form of permanent damage to the respiratory function of the body. In either case, the question of liability is going to be determined on the basis of any negligence on the part of the injured party, which may have contributed to the injury, and the reasonable design, labeling, warning, and whether appropriate remediation occurred on the part of the employer or the owner of the property. The existence of hidden toxic materials in a building, such as asbestos, may result in legal liability on the part of the building's owner. The law in this area is very complicated, and responsibility for damages can extend back many years and involve prior owners of the building as well. Medical proof that the disease or injury was in fact caused by exposure over time is also a very complicated and contested issue. Often, the victim had the opportunity to be exposed to the toxic substance at several locations over the period of his or her lifetime. Packaging, labeling, and proper instructions for the use of items such as household cleaning chemicals, manufacturing chemicals, herbicides, and insecticides are all things to examine in determining legal liability for injury and disease. The attorneys at Carlson, Meissner, Hart, and Hazlett have represented victims in Florida for injuries and diseases caused by exposures to hazardous chemicals and toxic materials. And those lawyers know how to properly investigate liability issues to support and prosecute a claim for damages.
Carlson, Meissner, Hart, and Hazlett, serving the community since 1971.